Good morning, everybody. I hereby call the House Standing Committee on the Judiciary to order. This is our fifth meeting of the session. And Robert, please call the roll.
Representative Banta,
Present.
Representative Blanton,
Present.
Representative Bratcher,
Here.
Representative Bray, Representative Burke, Representative Dietz,
Here.
Representative Doan,
Present.
Representative Flannery, Representative Herron,
Here.
Representative Colcarney,
Present.
Representative Lewis,
Here.
Representative Maddox,
Here.
Representative Mosier, Representative Nemus, Representative Petrie,
Here.
Representative Rawlings,
Here.
Representative Sharp,
Present.
Representative Stevenson, Representative Wilson,
Here.
Vice Chair Decker,
Present.
Chair Elliott.
I am here. And so we have two bills for consideration this morning. House Bill 333, an act relating to prosecution proceedings. Speaker Pro Tem David Meade, and if Representative Meade would come to the table with his guests and introduce himself and the guests, and then you can proceed.
Well, thank you, Mr. Chairman. Members of the committee, I am David Meade, Speaker Pro Tem of the House, and I have with me Jenny Oldham from the County Attorneys Association. As you see in this bill, it is a very simple bill. It just changes.
Motion on the bill.
Second.
There's a motion by Representative Petrie, a second by Representative Blanton. If you have a few more comments, I'll allow that if you want to, but you don't have to, obviously.
Shucks.
I will. I tell you what, we will defer to the committee if there's any questions.
Okay, that's fine. Is there any discussion amongst the members? Okay, seeing no discussion, there's a motion and a second. Would the clerk please call the roll?
Representative Banta,
Yes.
Representative Blanton,
Aye.
Representative Bratcher,
Yes.
Representative Bray, Representative Burke, Representative Decker,
Yes.
Representative Dietz,
Yes.
Representative Doan,
Yes.
Representative Flannery, Representative Herron,
Yes.
Representative Colcarney,
Yes.
Representative Lewis,
Yes.
Representative Maddox,
Yes.
Representative Mosier,
Yes.
Representative Nemus, Representative Petrie,
Yes.
Representative Rawlings,
Yes.
Representative Sharp,
Aye.
Representative Stevenson, Representative Wilson,
Aye.
Chair Elliott.
Aye.
Thank you.
So 17 yes votes and no votes and no pass votes. House Bill 333 is passed, and the same should pass with favorable expression. So
Thank you, Mr. Chairman, members of the committee.
Thank you very much.
Thank you. Our next item on the agenda is House Bill 385, an act relating to mental capacity. And the sponsor of that is Representative Moser, who's also a member of our committee. And she has some guests with her, so the floor is yours, Representative Moser. And if you would introduce yourself and your guests would introduce themselves, and then you can proceed.
Well, thank you, Mr. Chairman, and thanks to the committee for giving me an opportunity to talk about this proposal. I'm Kim Mosier, State Representative.
Pull that a little closer. Yeah, thank you.
I'm Kim Mosier, State Representative of the 64th District, and I will ask my guests to please introduce themselves, and we'll get started.
Hi, I'm Katie Comstock. I'm AOC Director.
Hello, I'm Colleen Slusher. I'm the director of the Kentucky Correctional Psychiatric Center, KCPC. Oh, green light. Good morning. I'm Stacy Tapke. I'm the Kenton County Attorney and past president of our association.
Okay. Thank you again for giving us a few minutes. House Bill 385 is a bill which allows a close friend who meets requirements to step in when family is not available to make health care decisions in the event that an individual is deemed by their physician to lack decisional capacity and has not executed an advance directive. The change in competency evaluations will ensure that individuals receive needed services in a timely manner and also that victims receive justice more quickly. Section 1 outlines that the individuals who can make medical health care decisions for an individual are listed in priority, ending with the adult friend of the patient who has maintained regular contact with the patient and is familiar with the patient's activities, health, and religious and moral beliefs. Sections 2 through 5 outline the procedures for competency evaluations. My guest will explain what all of these changes are, including guardianship and the reasons for these changes. Section 6 names this legislation Seth's Law, and it is named for Seth Stevens, a talented young attorney who unfortunately lost his life to suicide this past summer. This bill comes out of a recommendation from the Guardianship and Commitment Work Group of the Kentucky Judicial Commission on Mental Health. This is the commission that was initiated by the Administrative Office of the Courts and members of the Supreme Court. So at this time, I will invite my guests. I'm not sure who wants to go first, but yeah, thank you.
Thank you. Good morning again. I'm going to talk specifically about Section 1. This is the recommended change to add friend as a responsible party authorized to make health decisions under KRS 311.631. And this came out of the guardianship subcommittee, of which I am the chair. Our group has met over the past years to discuss all things related to guardianship. We meet regularly and we continue to meet regularly. And this was one of the consensus points of that group. So currently, when an adult is at the hospital and they don't have decision-making capacity, think someone who was in an accident, an elderly person who presents with dementia, and they haven't executed a power of attorney or a health care power of attorney to recognize an individual to make decisions on their behalf, the hospital then looks to the statute, which outlines the priority. They're going to go first to the spouse, then they're going to go to children, parents, and then any living relative. Currently, it doesn't allow for someone to have their decision maker be a significant other who they live with or someone who actually knows their wishes and desires. So the hospital then typically is going to call up state guardianship. State guardianship is going to do an investigation themselves to look and find someone who might be appropriate, because state guardianship is to be the absolute last alternative. So what's happening now, when they don't have a directive, they don't have any family, then they are being directed to the court, to my office, for example, to file for guardianship, particularly to seek emergency guardianship, so that they have that authority to make those decisions on their behalf. That is problematic for a lot of individuals, particularly those who are lower income. It creates barriers for them, both from taking off from work, transportation concerns, and the like. And oftentimes it's a deterrent for them for even stepping up to begin with, and then we default to the state. By allowing Kentucky to then allow a friend, and again, this isn't just supposed to be any person off the street who shows up. This is designed to recognize those significant others with whom they may live, someone who maybe is a good neighbor and a good friend who actually knows their activities, their religious preferences, to act on their behalf without having to go the route of coming down, filing for emergency guardianship, and that will help all the people involved, in my estimation, as someone who does these sorts of things on the regular basis. And to any concern that it would be a random person, the state could still be involved to make sure we're just not, allowing someone who doesn't know their wishes and beliefs to be involved. Thank you.
Based upon the groups that are present for support, Mr. Chairman, I make a motion.
Second. The motion there's a second. And I know you wanted to recognize one other person to explain if if you so wish to do that.
Well, Colleen, would you like to explain the competency piece, or maybe we can answer
I know
questions?
we do have some questions. So.
Okay.
Representative Flannery.
Thank you. Ms. Tapke, on page 1, you just discussed the adult friend. Is friend defined anywhere in this section? I guess my concern would be that that could be somewhat broad, and I wouldn't want there to be some potential of abuse on that.
I share your concern, and this definition specifically would say someone who has maintained regular contact with the individual and would be familiar with their activities, their beliefs. It's got to be someone that the hospital, I'm always mindful the hospital too is going to be not wanting to just recognize anyone, because I imagine, can't speak for them, but I imagine they're concerned about making sure that they have an appropriate decision maker. So I think this language, which is adopted from the Indiana statute, will address that. I have checked in with some colleagues I know in Indiana to see how it's been going there, and it sounds like it has been going well with them being able to recognize a friend. It's often the social worker at the hospital that's doing their due diligence to make sure someone's appropriate.
Thank you.
Thank you. And I think, too, if we were to make that too onerous, then the medical staff is having to go through that evaluation process as to who's a friend and who isn't. So if we make that too onerous, then that's going to be difficult, excuse me, for them to go through that process. Representative Sharp.
Thank you, Mr. Chair. Got concerns similar to Representative Flannery here. This regular contact doesn't seem to be identified what regular contact means in the context of this bill.
So again, you would be looking at, this is the last resort. So if the friend is not an appropriate party to make decisions, you will be looking at a state guardian ultimately, because there'll be no decision maker, and that will force all the parties through the court process. And then you would most likely have a state guardian appointed, and that individual would likewise not have any knowledge, particularly as to the person's wishes and desires. So this is trying to make sure we're allowing, again, significant others or people who know, in my experience doing emergency guardianships, most often it is someone who just hasn't married their partner and they have no other family, and I mean no other family. And also or I've had a neighbor, someone who went and checked on them on the regular, and they were willing to step up and do this. There's a lot of people who don't want that responsibility. It would make them quite nervous to be responsible for that medical decision. And they're not stepping up for responsibility over anything else other than being able to communicate wishes and desires to the hospital.
We're leaving this definition purposely a little broad to help out. Is my understanding that?
I think you would not want to be too restrictive. For example, Indiana includes priest or like a pastor. This would already allow someone who was a pastor, someone from the church, to come in and help make decisions.
Okay. How do they document their relationship?
So I don't know, because I don't represent the hospitals, but I would defer to the hospitals. I suspect that, again, they're going to have a pretty healthy process where they are going to document how they came to decide that they were going to allow them to be a decision maker. I did check in, like I said, with Indiana that has this already, and they said it has actually been going okay, and they have more conflicts amongst family members than they've had any issues with a friend stepping up.
This is going to then depend on the standard operating procedure of the medical facility then?
They would be, the doctor would and social worker would be looking for that decision maker. So yes, it would be up to them. Otherwise, again, what's going to happen and what currently happens, they're going to send the state or send the neighbor down to my office to file a petition for emergency guardianship, and then the court's going to likely appoint that exact same person, and you've just kind of created some steps on that friend to get that authority.
Thank you. Thank you, Mr. Chair.
Thank you, Representative Sharp. And I think one other point that I'd like to make is that if you look above in the statute, the nearest relative is who is the last person or the last priority on the list if a person doesn't have a power of attorney or a healthcare surrogate or a guardian. We don't go through the analysis of whether the closest or the nearest relative has had regular contact or whether they know, about the health, activities, religious and moral beliefs. They can just come in and say, I'm a relative. So there's no analysis with a relative, and I have some relatives who don't know anything about me. So, I think this is a good addition. So, Representative Bratcher.
What kind of decision, can you give me some examples of what kind of decisions are made in this context?
So in
Is
my
it life and death type?
It's not typically life and death in my experience. Most commonly, it is someone who probably has neglected their health, and they finally are at a point where they get to the hospital, and they probably have dementia or they have some condition that's leading them to not being able to make medical decisions for themselves. And so it's a lot of times our older citizens that are presenting to the hospital with not life or death decisions, more just that general care where they need.
Well, like what decision? Give me an example.
Just to be able to say, yes, you can have this, whatever medication or whatever the hospitals are seeking, that they would ask the patient, is this okay for? Also, I think they get towards the end, start looking to where they can safely discharge the patient. And a lot of times, if there's not a place for them to safely go, they're going to be looking for someone to be able to help find them a safe discharge plan, those types of things. But not typically, in my experience, not typically an ultimate life or death call.
So just medicine?
Just your general, I go to the hospital and I have dementia, and it turns out that I have maybe some stage 2 cancer, and I've got, some other conditions that I've neglected because I haven't sought care for myself, those types of situations.
And so they would ask the adult friend, does he have cancer? Or something like that? What?
I don't think like that. I think it's more of just, again, they need to have someone to be able to help them with all of the things that relate to care. And I'm sorry, I am not even close to being a doctor or a nurse, so I'm only speaking from the experience of the person who talks to the family member, the friend coming in to do guardianship.
I guess I can maybe jump in and just say, I would think that oftentimes it has to do with living conditions after a hospitalization too. How do we get the patient stable enough to go either home, that the friend might know what the wishes were of the individual? Do they want to go home? Do they want to go to long-term care? Do they want to go to hospice? They would be a little more knowledgeable about those issues.
But they could ask them anyway, right, Kim?
Well, I mean, if they're not mentally competent, that's the problem. If they don't have decisional capacity, if they just aren't able, that's the only reason for a guardian to step in any situation, whether it's a family member, a spouse, or a friend.
And then one just last, who is Seth? Why is it going to be called Seth's Law?
Seth Stevens was a young attorney with the administrative office of the courts, right? He was working for the Kentucky Judicial Commission, and he lost his life to suicide this summer. And so because we're talking about mental health, I think that's why it's appropriate here.
Okay.
Thank you, Representative Bratcher. We have another. Representative Petrie.
Thank you, Mr. Chair. I'd like to try to focus some attention quickly on Section 3 of the bill. In particular, Section 3, at the bottom of page 3, a defendant who intends to introduce evidence of his or her, and then we go to A and what looks like 2 A's, but I'm going to say A and B, mental illness, which is standard language, or intellectual disability bearing on the issue of guilt, punishment, or both, or existing language insanity at the time of the offense, and then we require a 90-day notice rather than a 20-day notice. I'm not sure why the 20 has been moved to 90. Having played both sides of the aisle in those cases, I can understand some reasons, but if someone could speak to that, and then more importantly, though, we're expanding to intellectual disability bearing on the issue of guilt, punishment, or both, not just mental illness. I do not see a definition in this bill regarding intellectual disability other than that may be contained within the definition of individual with an intellectual disability. I just want to make sure I know how far this is getting expanded, so it might help us understand how many more examinations may be requested. As criminal defense, if I have someone that is apparent to me sub-average intelligence, then I almost by necessity am going to have to do a 90-day notice in any case where there might be imprisonment of a day or more, and put that notice out there and request an examination through the court. If somebody can talk to that, please.
Sure, I'll start. Can you all hear me? Am I close enough to the mic? What you're seeing, the reason it was changed from 20 to 90 days is to mirror the criminal rule 8.07, which currently already requires 90 days. These statutes really haven't been touched in a couple of decades, so that was truly just a technical change to align it with the criminal rules. In dealing with someone with an intellectual disability, that requirement's already in another statute in this chapter. So what this is doing, again, is just mirroring and just making sure we're capturing everything. So it's not expanding it, it's just making sure it captures everything that's currently already in that chapter.
May I follow up?
Yes, go ahead.
And I appreciate the effort to alleviate the burdens on KCPC going with outpatient. Do you anticipate that there will be more examinations requested or more examinations completed in any given cycle, and what kind of physical impact there might be on that?
I'm going to turn it over to Colleen.
Hello, thank you for your question. So we have seen an increase statewide for the last 2 years, about 17% of increase in orders for competency evaluations. That's really kind of mirroring some national data as well. So we do anticipate there will be some, but not necessarily because of this change, but just the increase in those orders across the system. And the fiscal impact is certainly actually reduced through an outpatient evaluation process because there'll be fewer people at that higher level of care and inpatient.
And one thing, if I can clarify, outpatient is used in this, it really just means not inpatient at KCPC. So where these evaluations will be taking place is wherever that individual is. If they're in jail, that's where the evaluation is. If they're out on bond, it'll be in that. So I just want to say, I know there's been some confusion about that context, and it just means as defined, not in KCPC, in inpatient. Correct.
Very good, thank you.
Thank you. Just to change the order of business a little bit, we have some members who have, well, he needs to do that. Yeah, that's what he said. 2 members who need to register votes, and I'll recognize Representative Bray.
Yes, need to record a yes vote on House Bill 333.
And I'll recognize Representative Nemus.
Thank you, Mr. Chairman. I'd like to record a yes vote on 333. I have to leave and present in local government. I know I can't vote in advance. If I could have, I would have voted for this one as well. Thank you, Mr.
Thank you.
Thank you.
No, that's okay. Is there any further discussion? Did we have a motion on this yet? Okay. So seeing no further discussion, would our clerk please call the roll?
Representative Banta?
Yes.
Representative Blanton?
Aye.
Representative Bratcher?
Yes.
Representative Bray?
Yes.
Representative Burke? Representative Decker?
Yes.
Representative Dietz?
Yes.
Representative Doan?
Aye.
Representative Flannery?
Yes.
Representative Herron?
Yes.
Representative Colcarney?
Yes.
Representative Lewis?
Yes.
Representative Maddox?
Yes.
Representative Mosher?
Yes.
Representative Nemus? Representative Petrie?
Yes.
Representative Rawlings?
Yes.
Representative Sharp?
Aye.
Representative Stevenson? Representative Wilson? Chair Elliott?
Aye. With 18 yes votes and no votes and no pass votes, House Bill 385 is passed and should pass with favorable expression. So congratulations. Thank you very much for your presentation. Is there a motion to adjourn? There is a motion